As I said in my earlier remarks, last week, the first reading of the Regulatory Standards Bill passed Parliament under urgency. It was introduced to Parliament as part of the National and ACT Parties Coalition Agreement, which I have to say, though, National had no difficulty signing up to because it quite likes the ideas as well. And it establishes what the ACT Party calls good regulation through a set of regulatory principles that legislation would be measured against. Now, I've got to be honest with you. I would have thought that making good law was sort of what you're meant to do anyhow, and that you need a piece of legislation to actually make sure that you make good law seems almost Kafkaesque to me. Yeah, but, well, just what we need, more bureaucrats to tell the other bureaucrats what to do. So I'm not a fan of the Regulatory Standards Bill, and it's nothing to do with Te Tiriti, or the Treaty of Waitangi as it's more commonly known. It's just that I can just see that this is going to end up into more bureaucratic gobbledygook. Anyhow, the aim of the bill essentially is to set out the principles of responsible regulation. Now, I'm assuming that that's not just legislation, but it's also regulation. We'll talk to somebody who knows all about that in just a second. And the principles are that legislation should be consistent with certain specified aspects of the rule of law, not diminish a person's liberty, personal security, freedom of choice or action, or rights to own, use, and dispose of property, except as is necessary to provide for or protect any such liberty, freedom, or right of another person. And also not to take or impair property without the consent of the owner, unless certain criteria are satisfied. I would have thought all that was covered by the existing law and legislation and the courts in this country, but there you go. Anyhow, to talk to us about this, and you will hear a lot of the Regulatory Standards Bill, mostly to do with the Treaty of Waitangi, our next guest, Tuariki Delamere, would regard the Regulatory Standards Bill as the next great assault on Maori, all Maori in this country. But for the first moment, we're going to talk to Dr. Bryce Wilkinson, economist and senior fellow at the New Zealand Initiative, to explain why legal principles matter. He joins us now. Dr. Wilkinson, lovely to have you on. Thank you so much for joining us.
Yes, good morning, Michael. Can you hear me well?
I can hear you very well. Thank you very much. Listen,
Good.
you would have heard my introduction to this, and I am bemused that we need a new piece of legislation to tell the government how to make regulations and government in general. Can you explain to me why we need this?
Yes, I enjoyed your introduction, and I just the initiative published a 400-word article for me on Friday on this topic, and the last sentence was, "This bill should not be needed, but it is." So why is it needed? Well, we've got all these processes given the force of cabinet instructions already, and we've had them for over 2 decades, actually closer to 25 decades. So we've got regulatory impact statement requirements. We've got legislative guidelines, which back in 2000 were called Legislative Advisory Group Guidelines. And we've got a Legislative Standards Bill. There's noodles of stuff, a long list of stuff already existing, long-standing, which the executive government should be complying with. So we shouldn't be needing Parliament to actually pass a bill in Parliament, which gives Parliament greater clout over an executive government that is actually not doing what it's requiring itself to do. And the reasons why it's not requiring itself to do these things all the time is because sometimes it's a bit embarrassing and a bit inconvenient. So it'll use urgency and other measures to rush things through Parliament. And Parliament and the public don't really get told about the things which they would have been told about if the government had applied with its own requirements under the Cabinet Manual. So that's the problem, Michael. What should be happening is not happening, and you can understand why. Governments are trying to get a zillion things through and their programs through, and they're in a hurry, and they don't want to be distracted if it's going to be a bit embarrassing.
But
So
isn't it
hence the
ironic then that
proposal
this was
is just to give.
introduced under urgency itself? The first reading was heard under urgency.
Yeah, yeah, that's a bit of a surprise to me, and I didn't like it, and I'm not sure why it's happening. But yes, it's not a good look to start with.
No, I wouldn't have thought so either. Listen, the
No.
other, but so essentially what you're saying is that there is a whole series of legislations, guidelines, as you say, cabinet guidelines included, that try and ensure that New Zealanders are not suffering from bad law or legislation being imposed upon them, and that we need this bill to ensure that that does not occur. Is that what you're saying? Because in reality, the practice of that is not being observed.
Yes, yes, not enough at all, and it's a problem. So, yeah, this is simply a process where so the essential requirements are elevated to a higher status by the way of a statute. So Parliament's got more say.
Um, Although it's mostly about the rights of the individual, you'd have to say the principles of this bill. There is the suggestion that this is an untrammeled assault on Maori. Do you agree with that?
No, no, I just can't make any sense of that at all, and it's certainly not the intention. Uh, the principles we're talking about here come out of the English common law tradition, and they go back centuries. And they're designed to allow the state to do things while protecting individuals, minorities, Maori, Pacifica, anyone else, Gaelic, Greek, Scottish, from undue oppressive measures by government. So another criticism is that this is putting individual rights ahead of the collective, but actually it's the opposite way around. It's when the collective, through government, through parliament, is passing a law or regulation. This is just a check that this isn't being oppressive on the individuals. So it's fully permissive of collective action.
I'm interested, Bryce, on the relationship of the bill to, well, it defines what the role of courts are. Now, that would be lovely if we thought that the courts were an impartial and not activist organisation when it comes to a number of issues in our society. So I'm interested in the idea here as prescribed in the bill that the court's role for authoritatively determining the meaning of legislation is confirmed, and if the legislation or any law passed by Parliament authorises a minister, a state department or a state official to make a decision that may adversely affect any liberty, freedom or right of the kind referred to, the individual rights outlined prior, that you can appeal to the courts or another independent body. Doesn't that cut across the concept of that Parliament is sovereign?
No, no, not at all. The common law tradition is that the courts will accept parliamentary law as the law of the land. Their job is to decide how to fit it into the common law more generally when they're making a decision on particular cases. So this principle is absolutely bog standard going back into English constitutional history. And if we were using American jargon, we'd be talking about the separation of powers. So Parliament is supreme as the lawmaker, but the courts are supreme in interpreting the law when they come to apply it to a particular case.
What happens
And
when
we
they
certainly don't
interpret
want
it wrong,
politicians doing that.
though, Bryce? What happens when the law, when the judicial authorities get it wrong, or they misstate what Parliament intended, or they create law?
Well,
Can I give you an example?
yeah.
The principles of the Treaty of Waitangi. Now, they decided to create what those principles were in the absence of Parliament defining them. Is that what we really want Parliament, or the courts, to do?